Today we thought we would talk to you about employment, termination of employment, and recent developments in employment law. And we essentially decided to discuss three topics. So the first one will be categories of workers. The second one will be termination of employment. And when I say categories of workers, we're going to talk about the employment relationship and the differences between workers, employees, as well as contractors. And then finally, we're going to give an update on some employment law modifications that have been recently made. So I'm going to turn over to my colleague who will start talking about the categories of workers.
So we'll start with the employment relationship. Now, in order to have a better sense of what an employment relationship is it is important to be aware of the different categories of workers. In these next few slides, we'll go over the employee, the independent contractor, and the dependent contractor, and what having a relationship with each of these workers means for the individual and for the company. So let's begin with the employee. The first question companies should ask themselves is, what is an employment contract? Section 2085 of the Civil Code of Quebec describes the employment contract as a contract by which a person, the employee, undertakes for a limited period to do work for remuneration according to the instructions and not under the directions or control of another person, the employer. The essential characteristics of an employment relationship are the following. So as the definition suggests, the employer will control the quality and the quantity of work. The employer will impose rules of conduct and will typically require that the employee perform the work at the workplace. The employer will also supply the employee with the tools and equipment necessary to perform the work. The nature of the relationship is in T2 personae, meaning the employee must perform the work themselves. So in other words, if one of you is sick one day, you can't ask your sibling or your partner to go into work for you. And there will be an economic dependence of the employee on the employer. More specifically, because there is this exclusivity in the nature of the relationship, meaning the employee typically only works for one employer at a time, the employee's income is derived only from one source. And finally, employers will make statutory contributions and withholdings on income paid to employees. So to sum up, what we will always see in the employment relationship is this element of subordination. The second category of workers, which are commonly present in the workforce, is that of independent contractors or service providers. The Civil Code also defines the services contract as a contract by which a person, the contractor, or the provider of services undertakes to another person, the client, to carry out physical or intellectual work or to supply a service for a price which the client binds himself to pay. The contractor or the provider of services is free to choose the means of performing the contract, and with respect to such performance, no relationship of subordination exists between the contractor or the provider of services and the client. So based on these sections of the Civil Code, it's not difficult to guess what the essential characteristics of the services relationship are. We have them here. So there will typically be an absence of control by the client on the contractor. In other words, an independent contractor has a high degree of control and exercises the right to determine what work needs to be done, as well as where, when, and how much work is to be completed. As discussed just before, an employee exercises a lower level of control and is subordinate to his or her employer. With respect to ownership of tools and equipment, the independent contractor typically purchases, provides, and maintains his or her own tools and equipment in order to perform the services, for example, a computer or a cell phone. There is an opportunity for profit and risk of loss when we're speaking about an independent contractor. So if the worker assumes all of the risk of loss or chance of profit, the worker is less likely to be considered an employee. For instance, a worker who draws a guaranteed salary, regardless of the financial health of the client's business, is unlikely to be classified as an independent contractor. With respect to non-exclusivity of services and subcontracting, independent contractors are typically free to provide services to more than one client. Further, a contractor will generally have the ability to hire another party to perform the services, whereas, as discussed just before, this is not permitted in an employment relationship. And finally, the client will not make employee-related payroll deductions on the fees paid to an independent contractor, but rather will make applicable tax payments for services provided. So to sum up, we see that the element of subordination is absent from a services relationship. It is really as though the service provider is in a business for him or herself rather than for the company. Now that we know the main characteristics of an employment relationship and we have a better idea of what a services relationship is, to complicate things, a third intermediary category of workers has emerged under Quebec law. So this third category was already integrated in Ontario law and is described by the Ontario courts as those non-employment work relationships that exhibit a certain minimum economic dependency, which may be demonstrated by complete or near complete exclusivity. In other words, the relationship with a dependent contractor will present with many of the characteristics that we just discussed, but the individual is providing services exclusively to one company, and as such, his or her income is derived solely from this company. Now, why are we taking the time to bring this all to your attention? Why, as a company, is it important to recognize when in the presence of an employment relationship and when in the presence of an independent contractor relationship? Because as employers, there are obligations which include statutory contributions and withholdings on payments made to the employees. Employers must pay employment standards requirements such as overtime, vacation pay, statutory holiday pay. And if the relationship ends, depending on how it ends, employers are required to provide statutory notice of termination and reasonable notice of termination to the employee. So therefore, if, for instance, a company has been treating an individual as an independent contractor, when in reality the true nature of the relationship is that of an employment relationship, excuse me, then the company may be exposed to a financial liability for having to fail to comply with the obligations we just discussed. With respect to the dependent contractor, the courts say that although these obligations, namely the statutory contributions and withholdings and the payment of employment standards requirements, do not exist, the individual would still be entitled to a reasonable notice of termination similar to that owed to an employee, as we'll discuss in the next section, if the company decided to terminate the relationship. So I'll give it over to my colleague Stephanie for the next section.
Thank you. So the next section that we want to talk about was termination of employment. Now, oftentimes this is a discussion that we'll have at the beginning of the relationship, which clients typically don't enjoy that because they're sort of talking about the end as they're speaking about the beginning, but it's something that comes up at the beginning, and I'll explain why in a few minutes. And of course, it's something that comes up with a lot of our clients when they're contemplating terminating an employee. So it's definitely a call that we get most often from clients to strategize in terms of how to manage the termination of employment. Now, Quebec is a special place, as we know, and when it comes to employment law and specifically termination of employment, it is even more special, and it has certain rules that apply in Quebec which don't apply across all the other provinces. So in this section, we'll talk about management rights versus legal limitations. We'll talk about different types of termination for cause. And we will talk about termination without cause and what are employees entitled to when we terminate them without cause. So management rights and legal limitations. So of course, employers have a right to manage their employees. We all know that. So they can manage their performance, they can manage their behavior and attitude at work, and when necessary, they can impose measures up to and including termination of employment, which is all limited as it relates to certain limitations imposed by law. Now, certain legal limitations which we need to be aware of is that when you're proceeding with a termination, you always need to consider whether or not there's any restrictions according to applicable employment standards legislation which will apply in the present case. So, for example, you have the Act Respecting Labor Standards. There are certain restrictions there that you need to consider, which we will talk about, but there are recourses that an employee can file when you terminate them. And when you're considering the termination, you need to make sure that the way that you implement the termination, you are limiting any sort of liability that you can have under the Labor Standards Act. Of course, you have the same under the Act Respecting Industrial Accidents and Occupational Diseases. So somebody is on a workplace accident, ultimately you're terminating them for one reason or another. You want to ensure that you're able to justify your termination so that the employee can't later say, well, you're terminating me because I was on sick leave because I had a workplace accident. So that's something else you want to consider when terminating. And finally, of course, you have the Charter of Human Rights and Freedoms, and you want to ensure that your reasons for termination are unrelated to any prohibited reason of discrimination under the Charter. So with all of this in mind, you want to ensure that you have a right to manage your employees, but you want to make sure that you're within the limits imposed by law. So termination of employment for cause. This is often confused by many clients on when are we dealing with a termination based on disciplinary grounds and when are we dealing with a termination based on administrative grounds. Now, they are both termination for cause, which means that you will follow, and I will go through the different types, but you will follow certain steps leading up to the termination of the employee, and ultimately you will terminate them for cause with the intention, of course, not to provide them with severance. We'll call it severance for now. So it is very important that we are able to classify the termination in either disciplinary or administrative and make sure that we follow the proper steps to ensure that we're able to justify the termination. So firstly, on termination based on disciplinary grounds. So there are many different types of conduct that can warrant disciplinary measures and ultimately a termination for cause on this basis. Insubordination, theft of time, excessive lateness, and I can go on and on and on. I mean, we've seen many fraud. I mean, of course, there's more serious issues, but there are different types of conduct, and really it is a conduct that is directly related to the individual's omissions or inactions. So it's really something that the individual themselves are liable for and can be held responsible for. Now, when you're thinking of disciplinary grounds, what the courts are most likely going to look at is, have you applied progressive discipline? So if somebody, for example, comes to work late and you ultimately say, you know what, I don't like the fact that this person's late, I'm going to terminate them, the courts will look at that and say, well, is the sanction proportionate to the offense? And that's the third bullet on our slide. So can we justify the termination based on the offense that was committed by the employee? Now, if you have a serious misconduct, something like fraud, for example, you do an investigation and you determine that this person I had a case recently with a client in the retail business that they determined that the employee who was going to the bank and depositing money for the retail store wasn't actually going to the bank, and they found out through a quick investigation that the employee had stole $35,000 from the store. Of course, they immediately terminated for a serious reason and was not going to give a written warning for that, opposed to the employee who's late a couple of times. You might want to consider there's warning, there could be warning, written warning, suspension. There's different measures that you can apply before you actually proceed with the termination. Another point that's very important when you're talking about termination for disciplinary grounds, and I just talked about investigations, I can speak for an entire presentation all about investigations, so I won't get into the details about that, but one of the things that a good takeaway to always remember is that you have to ensure that you don't apply double measures. So if you are applying one measure to the employee to sanction them for a certain offense, you want to ensure that you're not then sanctioning them with another measure. So for example, you want to suspend an employee pending investigation. You have allegations of harassment against someone. You can't keep both of them in the workplace while you do the investigation. You decide to suspend someone. You would be suspending them in that scenario with pay because it's not a disciplinary measure. It's really to be able to perform your investigation. And then you would decide afterwards the outcome of your investigation and how you will deal with the individual, if at all, if there's any sanctions. What I've seen come up on many cases is that employers sometimes suspend an employee without pay, saying, sort of making a little bit of a call in advance, and then ultimately will terminate the employee, and the employee will file a claim saying that you've now double sanctioned me, you suspended me without pay, and now you've terminated me, and you've taken two measures for the same offense. So we want to be careful with that as well. I think the last point that I wanted to make here was the golden rule. The golden rule is, as much as possible, consistency. So you want to ensure that in your reaction to certain conduct that you're consistent throughout. So the way you treat, lateness, for example, you want to ensure as much as possible that you're imposing the same process and the same measures, for the employees throughout. So that's the overview of termination based on disciplinary grounds. Now, where there's a distinction is based on administrative grounds. So really what this is, the most common terminations based on administrative grounds are those where really it's as a result of the employee's inability to fulfill their obligations of the employment relationship. Perfect example is performance issues. The employee comes to work every day, the employee is doing their best, they're trying, but they're just not cutting it, okay? We'll go through the 5 requirements because that relates to that, but that's one example of when you might lead to a termination based on administrative grounds for performance issues. Again, inability to fulfill the obligations, not based on omissions and acts or insubordination that the employee is doing. The other common reason for termination based on administrative grounds is excessive absenteeism. So an employee, for example, who's on a leave of absence for an incapacity, and again, I'll go through the sort of requirements for that, but it's again not the person just showing up late, not coming in, not calling, not having a justification, right? That's an omission of an employee, but this is somebody who's on a leave of absence for extended period, and you need to make a decision as to whether or not you will continue the employment relationship. So let's take performance. I put up here 5 requirements imposed by case law. Now, what's imperative for clients to always remember, and it is probably the most often mistake made by clients, is that they don't necessarily follow the 5 requirements. Why? We have businesses to run. We have managers that are managing the employees, and they come, and I get this call probably every day. My manager's done, wants to terminate. The employee has 5 years of service, but we're done. We can't handle it anymore. Now, I'll talk about the recourses in a minute, but that it's the 2-year mark that really is most important for us to keep in mind as we talk about this, because an employee with more than 2 years of service has a claim that they can file for reinstatement if they believe they were terminated without just and sufficient cause. So when you're going through these 5 requirements, the courts really look at this and they say, have you made the employee aware of the objectives for their position? Do they know what they need to do? What is their role? What is their tasks? Have they been made aware of the issues and the need to improve certain issues? Did you give them sufficient time to improve? Did you give them sufficient support to improve? And last but not least, which is the one that always is sort of the missed one, did you inform the employee that at this point, we're going to give you sort of one last chance, and if you do not improve, then your employment will be terminated for cause. So it's very critical in order to be able to justify a termination for cause, especially when we're in a complaint for reinstatement, is to be able to show that you really went through those 5 requirements. When we're talking about absenteeism, of course, it's a little bit different because we're not trying to improve the person. You have somebody who's on a leave of absence for an extended period of time. I typically say, if you have somebody for 18 months, 2 years, and forward, you really need to look at this file and you need to determine 3 things. One is the presence of an excessive absenteeism, and that, in my view, from experience and case law and everything else, you're looking at not typically before 18 months. You are looking at whether or not the employee has provided proof that the employee will be unable to return to work in the foreseeable future. And that's very critical. Oftentimes I see that sort of proof coming in from the doctor, or if the employee is covered on insurance, it could be through the insurance company that you're receiving information which provides that the employee will not be coming back to work in a foreseeable future. And last but not least, the reasonable accommodation is, did the employer respect its obligation to accommodate the employee up to a point of undue hardship? Now again, we have businesses to run, you have positions that need to be filled, you need to give the person in the position that comfort that they're there and they're there to stay, but at the same time you have these legal limitations as we discussed. Most relevant for this one is the Charter of Human Rights and Freedoms, where you want to ensure that you've taken all your steps so that the employee can't later turn around and say, well, they terminated me because I'm on sick leave. No, we've terminated because it's excessive, medical proof that you have no foreseeable return to work, and we've assessed our business to see that we can no longer accommodate leaving this position open. So those are the termination without cause. Now, for the terminate with cause, these are the termination without cause is 3 different types of termination. So you have the layoff, which again is a termination that's unconnected to the employee. It is tied to the business and not the employee themselves, and it could be a restructuring or a termination of a position. Now, the termination without a serious reason is what I call a without cause termination, whereby the employer believes that the employment relationship is just not working out, the relationship with the employee, and no, we've not reached the cause or the performance issue, but it's just not a good fit, and ultimately they want to terminate and provide the employee with their termination entitlements. And lastly, we have a constructive dismissal, which, again, I could probably take an hour just to talk about that and all the different scenarios, but high level it is when an employer makes a unilateral modification to an essential term of an employee's employment. For example, classic example is a reduction of salary of 7 to 10% or more, changing the reporting relationship significantly where you're basically demoting the employee, and so on and so forth. So next, we will talk about entitlements. So when an employee is terminated, the first thing that we do always is I say to my client, I need to see the employment agreement or offer letter to see whether or not there's anything in there which stipulates what the employee can receive in the event of a termination of employment. So that's always the first step. The second step is we'll look at the statutory as well as the civil law entitlements that the employee has, and that is in cases in the absence of an employment agreement, or if we're in the context of an employment agreement that has a clause that's unenforceable or that doesn't really stipulate what the employee will receive in the event of termination. So firstly, we have a termination without cause. So we have a fixed-term employment contract. Now, a fixed-term employment contract, what I call a pure fixed-term employment contract, is one where the employee, we have an employment agreement with the employee for a fixed duration, and there is not a clause in the contract which provides that the employer has the entitlement to terminate the contract prior to the expiry of the term. It is, we are committing ourselves for X amount of time to the employee, and in the event that we want to terminate the employee without cause, we will need to pay the employee out for the remainder of the term. That's one scenario. The next scenario is an employment contract of an undetermined duration. So again, we will look at the contractual termination entitlements to determine if what is in the contract is enforceable, is it reasonable. Now, on that point, what is special about Quebec, and I said I would talk about some of our special points, is that in Quebec, an employee who has a contract that has a termination clause, which, when you look at the employee's profile, ultimately would not be deemed as reasonable notice, which I'll get to the different entitlements, but will not be deemed reasonable notice, the courts are not bound by that clause. Perfect example. You have a CEO who's been with the company for 20 years, who's 60 years old, makes $500,000, and you have a clause that says that he gets the minimum statutory entitlement under employment standards legislation, which is 8 weeks. It's clearly not reasonable or enforceable. So courts will not look at that clause and say, well, you have a clause in your contract, we're bound by it. They're not bound by it. They will put the clause aside and they will determine, based on the profile of the individual, what is reasonable notice. Let me just see. So essentially what we need to do is we need to look at the employment contract. We'll look at the clause. Assuming the clause is not enforceable or we deem it to be unreasonable, employees, non-senior manager employees, would be entitled to a minimum statutory notice, which is 1 to 8 weeks depending on the years of service. And they would also be entitled, including senior managers, to what I said was a reasonable notice of termination of employment. Now, the way that we determine what's reasonable notice is, as I said, you look at the individual's profile. What is their position? What is their compensation? What is their age? And essentially what we are trying to determine is, taking into account their profile, how long would it take this individual with that profile to find comparable employment? And we will come up with an assessment as to what would constitute reasonable notice for that individual. Now, my big exclamation mark as attention is, as I said, in Quebec, somebody with more than 2 years of service who is terminated can file a claim for reinstatement into the company in the event that they feel that they were terminated without just and sufficient cause. So it's very important, if we leave today talking about this topic on one point, it's when you have somebody who's reaching their 2 years or who is past their 2 years, who is not a senior manager in the company, we need to be very careful as to how we proceed with the termination, because again, courts will basically look at this and say they have more than 2 years, they weren't terminated for cause, they're allowed to be reinstated. And reinstatement means back pay from the termination date all the way until the date the decision's rendered, which right now is up to 2.5 years of pay, less any amounts they would have received had they received anything during that period, plus reinstatement in the position. So we need to be very careful when we're around, sort of leading up to that 2-year mark, or if we're past that 2-year mark and your manager calls you and says, this employee's here for 3 years, but I can't take it anymore. No, we haven't really managed the employee, but we want to terminate and we want to do it tomorrow. That's when you put your brakes on and you say, let's figure out how we can strategize about this. Last point before I turn to my colleague is the Act Respecting Labor Standards also has other recourses that can be filed. So there's the prohibited practice complaint. Again, is if somebody is on sick leave, they're pregnant, they were on maternity leave, whatever right that they are exercising pursuant to the Act, and we terminate them, they can file a complaint to say that they were terminated as a result of exercising their right under the Act. So again, we want to be strategic in how we deal with those files as well. And finally, of course, we have the psychological harassment complaint that could be filed. Again, I know I've said this a lot because a lot of these topics are ones we can talk about for an entire day, but typically when you terminate somebody that has more than 2 years of service, they typically, in my experience, find a way they'll file the 124, so the reinstatement complaint, and they'll file harassment and say that they were subject to harassment in the workplace. The other recourse that can be filed is under the Civil Code, the employee can file for reasonable notice. So if the package that you offer them they believe is not reasonable, they can file a civil claim for reasonable notice for what constitutes reasonable in the circumstances, taking into account their profile. And finally, we have the two that I talked about, which is the Act Respecting Industrial Accidents, the prohibited practice complaint, as well as the discrimination complaint under the Charter. So this sort of brings us back to our legal limitations that we want to consider when we're proceeding with a termination. So I will go on now to discuss recent developments in employment law. So firstly, we will talk about cannabis in the workplace. That's been quite the hot topic most recently. And then I will turn to my colleague who will talk about the amendments to the Act Respecting Labor Standards, which has also been for us many calls that we've been receiving lately. So for the Cannabis Act, so as we all know, the Liberal government released the Cannabis Act April 13, 2017, which came into effect October 17, 2018. Now, each province had the mandate to update its legislation to account for the legalization of marijuana, while, of course, remaining within the limits imposed by the Federal Act. So Quebec enacted the Cannabis Regulation Act. Now, this act governs the possession, the cultivation, use, sale, and promotion of cannabis. It prohibits possession in certain places. It prohibits smoking in all places where tobacco smoking is prohibited. And it also governs the workplace in that it specifically provides employers with the ability to prohibit cannabis in the workplace. And it has made amendments to the Occupational Health and Safety Act as well, which essentially provides that employers do have a right to regulate, including prohibit any form of cannabis use by their employees in a workplace within the meaning of the Act. So under the Act, as I said, the Act respecting occupational health and safety, really what it did was it includes an express inclusion of cannabis with respect to the employee's obligation to perform their work safely. So there's two covenants that they brought in, which essentially says that a worker cannot perform his work if his condition represents a danger to his health or safety or anybody else. And they also implemented a clause to say that the employer must see that the worker does not perform any work if his condition represents a risk to the health and safety. So it's an employee obligation as well as an employer obligation. One of the most common calls that we got from clients, and we're still getting, is, well, what about our policies? So surely the plan of action for employers is revise your policies. And what's very critical is to ensure that there's clarity in your policy that now something which was illegal before now being legal, you want to ensure that your policy does not in any way insinuate that now that it's legal that they're able to come to work under the influence. Now, my first reaction to my clients has always been, for me, you tell me you don't want cannabis in the workplace, there's no difference between alcohol as there is for cannabis. You can't come to work drunk, you can't come to work high. Now, clients will say to me, but what happens if my employee, they step outside and they smoke? I mean, they're allowed to smoke, I can't prevent it. No, but you can prevent them from coming back to work under the influence. Another question I get is, well, we don't have safety sensitive positions. Is there a reason why, do I have to give a justification? No, you don't have to give a justification. Now, I won't get into this in detail, but of course, like anything else, you have the duty to accommodate your employees if somebody's coming in with a medical use of marijuana. There's always that question as to whether or not there is a way to accommodate the employee's use at the same time as allowing him to work. And that's something that each company needs to determine on a case-by-case basis. So we've been reviewing the internal policies, and very important, it sort of seems like an obvious comment, but we need to distribute the policies, we need to train the employee on the policies, and we need to make sure that we review it. I have too many clients that say, no, we have a policy, but the policy literally is in that cabinet on the floor, and no one's really read it, no one signed off on it, and now we can't really enforce it. So if we want these policies and all the work that's brought into them to actually have some value to them, it's because they've been distributed and they've been reviewed for the employees. And last but not least is the consistent application of the policy. So no different than anything else, you want to apply the policy consistently along for all the employees. That's it. I'll leave it to you for the amendments.
We'll now take some time to go through the amendments that were made to the Quebec Act Respecting Labor Standards. The amendments can be grouped into 4 general themes. as you see here: work-life balance, psychological harassment, personnel, leasing agencies, and equity. We'll start with work-life balance. The Quebec government's position is that workers, and particularly younger workers, are looking for a work-life balance, and the amendments to the Act reflect this rationale. So quite a few amendments were made to the Act under this theme, particularly as it relates to absences and personal leave. We won't be going through all of them today, so today we'll only talk about those that we see or that affect employers on a more regular basis, but just know that there are more than what we were going through today. So with respect to annual vacation, employees are now entitled to 3 weeks of annual vacation upon hitting 3 years of service versus 5 years of service in the previous version of the Act. As it relates to hours of work, the Act was amended so that employees can refuse to work more than 2 hours after regular working hours. In the previous Act, it was 4 hours. Employees also have the right to refuse work outside of their normal work schedule when they are not advised that they would be required to work at least 5 days in advance, subject, of course, to certain exceptions. With respect to statutory holidays, where a statutory holiday falls on a day that is not part of an employee's regular working day, the employee is now nonetheless entitled to statutory holiday pay. With respect to sick leave, statutory sick leave in cases of sickness, accident, or organ or tissue donation remains at 26 weeks over a 12-month period, but now also applies to leaves in cases of domestic violence or sexual violence of which the employee has been victim. Moreover, and importantly, the requirement for employees to have at least 3 months of service to be eligible for those leaves has been removed. Further, an employee with 3 months of service or more will be entitled to a maximum of 2 days paid leave during a given year for absences related to sickness, organ donation, accident, domestic or sexual violence, or for reasons related to the care, health, or education of family members, whereas with the previous version of the Act, these leaves were completely unpaid. Family or parental leave of absences. The provisions respecting statutory leave for the fulfillment of family or parental obligations now clarify the term relative and are brought in to include certain days of absence for the benefit of a relative other than a family member, including for a person for which the employee acts as a caregiver. That said, the Act was also amended to add that an employer may request that an employee who is absent for reasons relating to the health, care, or education of family members provide a document attesting to the reasons for the absence if the circumstances so warrant. The second theme is psychological harassment. As it relates to the definition of psychological harassment already included in the Act, presumably influenced by current social issues and movements and the recent legislative changes in Ontario, the Quebec legislature has chosen to expand the definition of psychological harassment to include sexual harassment. This amendment essentially codifies existing jurisprudence. With respect to prevention policies, this is something that we always recommended to our clients to have, but the Act now has been amended to expressly require employers to adopt psychological harassment prevention policies and the handling of complaints. Again, this legislative requirement is consistent with the importance given to prevention policies in case law. And as it relates to filing a complaint, importantly, The time limit for filing a complaint by an employee alleging psychological harassment has increased from 90 days to 2 years from the last incident of the offending behavior, which you can imagine was a scare for our employer clients. With respect to the third theme, the Act also incorporates substantial modifications which are aimed at regulating employee leasing agencies. These provisions will come into force upon the adoption and the entry into force of a regulation pertaining to employee leasing agencies. Firstly, the prohibition against paying workers less because of their employment status is expressly expanded to cover agency employees. So this means that an agency worker may not be paid less for the same work, less than other employees for the same work in the same establishment, solely because of his or her employment status as an agency employee. Also, importantly, the agency and the client enterprise will now be jointly liable for any pecuniary obligations respecting agency employees. Secondly, personnel placement agencies and recruitment agencies for temporary workers are now required to obtain a license from the CNESST, so the Quebec Labor Standards Board, in accordance with regulations which are to be enacted. So employers will not be permitted to retain the services of such agencies who do not have the required license. And thirdly, employers hiring temporary foreign workers are subject to additional obligations, including the obligation to advise the CNESST upon the hiring of a temporary foreign worker, the worker's date of arrival, and the duration of the employment contract. Finally, employers cannot charge fees to foreign workers for the recruitment, except those authorized under Canadian government programs, and they may not require temporary foreign workers to hand over personal documents such as a work permit or a passport. And finally, the amended Act also aims to enhance workplace equity with respect to wages, including to ensure that there is no discrepancy between employees that are performing the same type of work in the same establishment, as was discussed with employee leasing agencies. Moreover, the amendments added a new restriction regarding so-called orphan clauses. The previous version of the Act already prohibited orphan clauses, meaning the application of less favorable working conditions based solely on an employee's hire date. But the Act only did this with respect to certain matters covered by the Act itself, and according to case law, these matters did not include pension plans and other employee benefit plans. So as such, many employers were creating two-track benefit and pension plans. For example, many employers grandfathered existing employees under defined benefit pension plans, but provided that all employees that were hired after a certain date would participate in defined contribution plans. The amendments to this Act would no longer permit these type of arrangements, as they expand the scope of the prohibition to include pension plans and other employee benefits. That said, the amendment only applies prospectively as of June 12, 2018, and would not apply retroactively to orphan clauses that were in force before this date.
So I think you're going to sum up, right?
Yes.
I think the one thing, if you don't mind, before Stephanie talks a little bit about the takeaways, With respect to the amendments to the Act, I think one of the things that employers need to really think about are some of their provisions in their policies. What I've seen come up quite often, for example, is there's 2 paid days now, okay, for different reasons. Now, oftentimes, what employers have in their policies, they already give employees 2 floating days, 3 days paid for the first few days of sickness, whatever it may be. And then the question that has come up on many times is, well, wait a minute, do the days that I provide them, are they inclusive of the days that they're now allowed to take under the Act, or are they in addition to those days? Because I never intended to give my employees 5 paid days. I mean, I intended to give them 3 days. So something to think about is whether or not the policy needs to be amended in order to reflect the number of days that they would be provided that are paid, and if this will be inclusive of the paid days. The other part that I just wanted to say, of course, vacation. I mean, vacation, oftentimes it'll say after 5 years you'll get more, but that'll be something that they're entitled to by virtue of the law, whereas the paid days becomes integrated into what you already provide the employee. So that's important to think about that. The other part that I wanted to mention was the harassment policies. So what's becoming also very important, and one of the modifications as well, is that employers must have processes and procedures in place in how to deal with harassment complaints. So again, employers are coming back and looking at their policies. I have clients who, for whatever reason throughout the years, never really updated their policy. They don't have one, or they don't have a very good one in place. So they took the opportunity now, include sexual harassment, and as well include a more comprehensive process policy as to how complaints will be dealt with. So just a couple of takeaways that I wanted to mention in terms of thinking about how does this really impact us from a practical perspective. There we go. I'll let you do the takeaways.
So, and this brings us to the end of our presentation. So with that, we hope you are able at least to take away the following. When entering into an agreement with an individual, be mindful of, categorizing this or classifying this individual properly as an employee, an independent contractor, or an independent contractor. When terminating the employment relationship, be aware of the rights and obligations that are imposed on employers, either by contract or by law. And finally, be aware of the amendments to certain legislation regarding cannabis in the workplace and the employment standards, and keep in mind how that will impact the businesses going forward.
Well, thank you very much, everybody.